But here's something else I want us to talk about here, is this use of executive power, which is really circumventing something that historically our nation works on, legislative consensus. And so we're seeing this increasingly. You know, the 1976 Emergency Power Act empowers the president to activate special powers during a crisis. But everything can't be a crisis. And we're seeing this more and more. So what's behind it? Joining me now to talk about this is Andy McCarthy. He's a former Assistant U.S. Attorney for the Southern District of New York and is a senior fellow at the National Review Institute. He joins us by phone. Andy, welcome back to the program.
Tony, great to be with you.
Okay, is it just me, or are we seeing this use of executive power and emergency powers more frequently today?
Well, we've seen it actually. It's more notable, I think, today because the Supreme Court is more likely to take challenges on an emergency basis, and it's become more routine for people to kind of run into court and try to get these executive orders overturned. But it actually is a dysfunction of our law, Tony, that goes back decades. And I think it's part of an overall trend of Congress essentially abdicating its responsibilities. It abdicates some to the courts, some to the bureaucracy, and some to the executive branch, along with the administrative state. And what it does, it's not just that one statute, which is the most important one that you just mentioned. There's about 130 emergency statutes in our law, which make it possible for the president to, in federal law, which make it possible for the president to invoke emergency powers for this, that, and the other reason. And then those have been expanded by the executive branch over the years. So, for example, Biden's favorite one has become the Defense Production Act. He declares emergencies under the Defense Production Act and does all kinds of stuff, even though, you know, we're not at war. We're not in a situation where the ramp up that the Defense Production Act referred to and is kind of a response to is the famous steel seizure situation in the Korean War, where basically the Supreme Court said that Truman couldn't nationalize the steel industry, right? And that led to some consideration of how much a president in a case of a true emergency should be able to marshal the capacities of the government to respond to the emergency. But obviously something that began with good intentions has gotten way out of whack.
Well, it almost appears, Andy, as Congress has really given its authority to both the president and to the courts, that's why I think we see most issues being decided either by executive action or then going to the courts. Congress, while they make a lot of noise, really they're not doing a whole lot because they've given their authority away.
No, that's exactly right. They seem to think more and more that their job is to, basically abdicate their authority or delegate it and then go on cable TV and complain how bad things are. But I think what we saw at the end of the Supreme Court's term, particularly the EPA case that it decided, I think, the last day of the term, is the court trying to sort of restore constitutional order by climbing onto this idea of major questions. So, in other words, what the court is now saying is if the bureaucracy, and that would include the executive bureaucracy, obviously, if it wants to try to enact policy that is going to work a major change in, for example, the relationship between the individual and the state, or the relationship between the sovereign states and the federal government, the bureaucracy is going to have to show that Congress enacted a provision that specifically allowed that. They're not going to be able to stitch together, like with the courts, they did it with emanations from penumbras, right? You're not going to be able to stitch together a bunch of regulatory provisions and figure they have penumbras too, and craft out of that, a regulation or an interpretation of a regulation that allows you to make sweeping changes. So I think
it seems like this. Yeah, I was just going to say, it seems like this court is actually trying to put authority back to where it belongs as to the Constitution, because even in the Dobbs case, what the court was saying. This isn't ours to decide. This goes back to the legislative bodies to decide. But honestly, most of those at least Congress, really hasn't wanted to deal with that issue. They would like to sidestep those hard issues because it's politically risky.
Yes, that's exactly right. They're elected to be accountable, and then being accountable is the last thing they want. But I'm glad that you mentioned that this was sort of thematically what we saw from the court in this term, because I think they're being accused, especially what I regard as the constitutional conservative block of the court, has been accused of usurping authority. And I think what they've done is quite the opposite. They're trying to restore the constitutional boundaries, and if anything, they've divested the court of authority and given it back, whether to the states or to Congress or wherever it's properly exercised.
So very quickly, we got 30 seconds left, Andy, but should Congress take a look at some of these statutes that have given away authority to the executive branch and take back that authority that's theirs under the Constitution?
I think they absolutely should, Tony, because, we're in a modern era where Congress can, on a dime, convene, right? We're not talking about an era anymore where, Congress is weeks away from Washington and the president has to be able to react to crises. There's no reason that we have to act like we're in a constant emergency when we can react to emergencies.
Right. Andy McCarthy, always great to talk with you. I always appreciate your insight and understanding of the process.
Thanks so much, Tony. Appreciate it.